Good afternoon, everyone. I am GND, the Executive Director of the Center for Digital Innovation and Legal Innovation Digital Society here at CUHK Law. So today we have the great honor and pleasure to have Dr. Xiong to give a talk on trade secret, AI, and public health. So let me briefly introduce Dr. Xiong. So she is a senior lecturer in law at the University of South Australia, so which will transition to Adelaide University in 2026. So she's an expert in a number of different areas, so including intellectual property, comparative law, trade law, etc. Before joining the University of South Australia, Dr. Xiong was with Victoria University of Wellington. So I'm sure, so a lot of you, myself included, so are really looking forward to this very, very timely, important presentation by Ping. So Ping, so I'm now giving you the floor.
Okay, thank you, Professor Lee. Thank you very much. Let me just first get my slides and then share my slides. Okay, and hope that I will get into this slideshow. Okay, thank you, Professor Lee, and hello, everyone. As Professor Lee has introduced, my name is Ping, and I'm a senior lecturer at the University of South Australia, which will be transitioned into Adelaide University from 2026. It's really my great pleasure to be here at the Center for Legal Innovation and the Digital Society of the Chinese University of Hong Kong. And I would like to begin by expressing my sincere gratitude to the organizers, so Professor Lee, Cherry, all these people for putting this event together and also let me to be part of it. And I'm really grateful that I can use this forum to share one aspect of my research and thoughts, and hope that it can be engaging and valuable, and hope that I can get your comments and feedback. And today I'm going to talk about trade secrets law and also public health in the context of the emergence of artificial intelligence. And what I would like to talk about is that I would like to propose some kind of a model for the governance of artificial intelligence. And I would like to argue that maybe a reflexive legal approach to the governance of artificial intelligence is a more pragmatic response to the challenges posed to public health and trade secrets law. And today I would like to first start with some kind of issues, and I will try to present the potential maybe conflict between trade secrets protection and also public health, maybe specifically the transparency requirements on the public health. Okay, you can see the potential conflicts. Then I will further explain the intersection of trade secrets law and public health, especially in the context of the emergence of intellectual property right, in the context of the emergence of artificial intelligence. And then I would like to introduce the literature for reflexive law and talk about the possible governance model of artificial intelligence to see how it can respond to these issues at the cross or intersection of trade secrets and public health. And also would like to show some of these kind of guidance or ethics in the self-regulation for the transparency in AI. And finally, I will offer some concluding thoughts. Hope that I can get your feedback. And we know now that the artificial intelligence is developing very rapidly. This kind of rapid development is through we call it the fourth generation of industrialization. It has transformed the societies and industries. And also, we can now see an increasingly important role of using artificial intelligence in improving public health. And especially now, when we talk about artificial intelligence, the concept of artificial intelligence, it is embedded in a range of technologies, right? Like algorithms, maybe big data. You talk about like expert systems, robotics, or other technologies like machine learning. Especially now we talk about the public health. Public health, in fact, how the AI works on public health is machine learning or deep machine learning. Deep machine learning now refers to like a machine can act or respond independently with little or no human input, and then by which maybe algorithms is able to maybe process data or to try to work on some kind of languages, and finally they can get inferences or conclusion, or maybe can draw kind of predictions. So now we use this kind of artificial intelligence also can use for improving public health. For example, you can use the artificial intelligence in diagnosis and the clinic care, the drug development, and public health, maybe surveillance, outbreak responses, and also the health system management, right? If you have a pandemics or other kind of health disaster, then you can use the system to, for example, develop a kind of evacuation plan or this. Of course, it's the use of artificial intelligence will benefit society, all of us. At the same time, it can pose some kind of challenges to us. It can include some ethical and legal challenges, among which we can think of some like data security, privacy, and the transparency issues. So whether you need to maintain the transparency of the data or the artificial intelligence technology or not. So today, what I'm going to focus on is on one of the issues is the transparency issue, to discuss the transparency issue and also its potential conflict with the trade secrets law, and also to try to draw upon some literature to talk about maybe the self-regulation, or draw upon the literature of reflexive law to use self-regulation to govern artificial intelligence. So now let's first look at the transparency in public health. We know transparency is not new concept in healthcare sectors. And in the healthcare sector, we always have some obligation to share certain information. For example, between the clinicians and patients, you have an obligation to share the information. So you have to maintain certain transparency. And also transparency in public health refers to the open, honest, and timely sharing of the information. Of course, in this information sharing process, many stakeholders can be involved. So you can involve, for example, maybe the government agencies, maybe the healthcare providers or institutions, or maybe academics or researchers, or because it's a public health issue, the general public, and also the private sector and also industries can also be the stakeholders, right? They all have to get involved in the whole process. And then this kind of to maintain this transparency is very important, because transparency is a key to trust. They can build a trust, among between, like, for example, the public and the private sectors, and also the public and the government, the different stakeholders. And also it's a key to accountability. And it supports informed decision making among both the public and the policy makers. Of course, it's also one of the very important common ethical artificial intelligence principles, transparency. But when we talk about transparency in public health, that means that we have to share some of the information to the general public or to the stakeholders. But when we use artificial intelligence to improve public health, it may cause conflict with the another law called the Protection of Trade Secrets Law, if you want to get the information shared or if they're required to disclose some information. So what is trade secrets law? Trade secrets law protects confidential business information from being disclosed or misused by others. And then if you go to, say, Article 39 of the TRIPS agreement. TRIPS agreement is the trade-related aspects of the intellectual property rights. It's one of the covered of agreements of the WTO law. And also in that law, it requires that the members of that treaty, they have to provide the protection of undisclosed information. So the undisclosed information is like trade secrets, but as long as they tick the boxes, they got three criteria. The first is that the information is being kept secret or the nature of the information is secret. The second box is that it enjoys economic value or is that the information got some commercial value. The third is that it is subject to reasonable steps to maintain secrecy. So if you tick all the boxes, then you can say this is trade secrets, and then they have to offer the protection of the trade secrets. So in this case, we talk about AI, artificial intelligence. We can think that artificial intelligence developers or deployers, maybe they will use this to protect some of their part of the technology as trade secrets. For example, the unique algorithms or the models they developed by the companies or deployers, developers, they can be seen as a trade secrets. Others like how to train the AI models and also the data used to train the AI models. All this can be treated or considered as trade secrets. The other one is like processes, the methods used to train this kind of model. All this can be treated as their trade secrets. So now you see that this one can be protected as trade secrets, but in public health context, maybe according to transparency principle, you probably need to disclose or share some of the information. So how should the trade secrets law be understood to respond to public health in relation to development of if you want to develop the governance rules or laws in each country about AI, artificial intelligence? So how should it be understood? So maybe some people will argue that, nowadays, lots of AI developers, deployers, they keep an open source code, right? Did they release the source code to everybody? But in fact, in reality, the businesses or developers or deployers, they still prefer to use trade secrets to protect their trade to protect their AI technologies. For example, ChatGPT, they only disclose the half of this source code. The other half they still maintain as trade secrets. Or even they developed some kind of even the source code of this, then the data, how they train the data, how they manage this, the methods to manage this, they're not going to disclose to the general public, okay? So they still can be treated as their trade secrets. Why they would like to use trade secrets to protect their, maybe this kind of health-related AI algorithms, data, or other methods? You can think about this. First is that AI algorithms are great intangible assets of the healthcare providers. It can also be well suited to protect a rapidly developing the changing marketplace, while this kind of patent will become meaningless. Because people will argue that, why don't you patent it? If you go through a patent protection process and then you get it granted to you, then you can disclose the information, then no one cannot use it, right? But AI technology is developing very fast. The development pace is very fast every day. The constant change, maybe the technical life cycle is very short. So maybe in that way, it's not good to use patent to protect it. It's better to use trade secrets to give immediate protection. And the second is that, for patent protection, it can be costly and time consuming. I'm not sure whether you got like a patent attorney among the audience or not. And then if you do patent application, you know that it's a time-consuming process because you have to file the application, and then you have to wait for, like, say, 1 year, right? Because you don't know whether somebody else claimed the priority or not. And then after that, you probably your competitor, others will challenge it, raise opposition. After the whole process, finally get the patent granted, can be several years. And also it can be very costly because think about this is jurisdictional. You go to different jurisdiction to get the patent protection. Of course, it can be a very costly process. But for trade secrets protection, they can be cost effective and also can help to gain the immediate protection. You don't need to do anything. You just keep it secret, maintain the secrecy, then you get protection. And also lastly is that the patent protection is subject to a patent term for protection. And the information will get into the public domain once the patent expires. For example, standard patent usually lasts for 20 years, and then it will be in public domains. But trade secrets protection can be different because, as long as you maintain the secrecy, you keep it secret, it can be your perpetual rights. You can earn as long as you like, right? Some people say that Coca-Cola is got their trade secrets, recipe, right? That's why they still, how many years, hundreds of years of this company, and they still can own it as trade secrets. So that's why you can see that, this AI or artificial developers, deployers have the incentives to maintain trade secrets in their AI technology algorithms or the data or methods. So now let's look at trade secrets law. So how did trade secrets law got developed? You see, if you look at the historic development of trade secrets law, the history of this, it really reflects the uncertainties or ambiguities of the justification of a trade secrets law. When we talk about trade secrets law, what's the justification behind it? Is that a breach of confidence? Breach of contract? Is that property, like intellectual property rights? Or it's just one aspect of an anti-unfair competition law? So in Anglo-Australian law, in Australia, we can trace this to maybe we use breach of confidence to protect the trade secrets, but it can be traced to the early English case in the mid 19th century case. In 1849, we have the Prince Albert and Strange case. In that case, the court said that there's a distinct concept of breach of confidence, and also it can impose to the institute, the conscience of the one or the people to whom the secrets or secret information communicated. So that from that case, the statute protection, of course, a breach of confidence to protect the secret information. And later, of course, in Australia, specifically got software engineer and Campbell engineering case, they established that the breach of confidence is a standard or norm cause of action. Okay, that's why you can use this to protect your trade secrets. Anyway, here they use the breach of confidence, and same as maybe the British law, they have the common law, use common law, and this is based on the law of equity to protect these trade secrets. But other jurisdictions like United States, that's an interesting case. In the early 19th century, also the early cases also shows that they also established the general duty of breach of confidentiality or breach of confidence. But later, I think that they start to think about others. They think, well, there's a tort law. They use like in the 1939, the restatement of torts. They talk about the tortious concept to protect trade secrets. But later, with the development of the Uniform Trade Secrets Act, that one is really a milestone in the development of the trade secrets law. Because in that law, they try to unify the law, and then they try to codify the protection of trade secrets. And in 1896, finally, they issued this, but this is just a model law. It's up to each state to adopt this UTSA, or Uniform Trade Secrets Act. So far, most states, I'm not sure, I didn't count now, maybe it's 48 states among all the 50 states in the United States have adopted the Uniform Trade Secrets Act. But interestingly, some like a commercially important state like New York, this hasn't adopted this law. But in 2016, United States has issued this Defense Trade Secrets Act, which established a federal level for a course of action for the protection for misappropriation of trade secrets. In addition to that, they also have a Economic Espionage Act to criminalize the theft of trade secrets. Anyway, in United States, they now use the statute also to protect trade secrets. In other jurisdictions like continental Europe and China, they probably regard it as an aspect of unfair competition. For example, in China, we have the law against unfair competition to protect trade secrets law. And European Union is the same, but in 2016, European Union issued a EU trade secrets directive. And then also in 2018, United Kingdom also issued a trade secrets regulation to bring themselves in line with the EU directive. But in the United Kingdom, the United Kingdom, the UK's trade secrets regulation complements their common law breach of confidence to protect trade secrets. In a word, this kind of a different justification for trade secrets protection in the historic development of trade secrets law reflects that this is and shows that this is still a murky area. It may also cause some kind of discrepancies in the enforcement of trade secrets law. And for the criteria for trade secrets protection, usually they got 3 criteria. I mentioned the concept before. You needed to make sure that the information itself is in secret. But this secrecy means that it's a relative secrecy. The relative secrecy means that it does not have to be absolute secret. The secret is sufficiently enough. It's sufficient if it can derive value from maybe not generally known or ascertainable, maybe by certain kind of people, especially by the competitors. Then that's enough. And also, they say that the secrecy is relative, is based on you have taken reasonable steps to maintain the secrecy. Of course, this also depends on the commercial value. If the information is worth a large amount of commercial value, then of course the court will look at that circumstance, because it's circumstantial. They will think that you are supposed to, of course, in that situation, you're supposed to take more restrictive measures, right? Because otherwise, this is a large value will get lost, right? Depending on different circumstances. Some maybe got little value. They look at their circumstances in the other situation. And also, this means also that if it's sometimes this relative secrecy means that the secrecy can be shared with some people, like your employees, contractors, partners for these people. And also it also means that if it's not readily accessible by someone, especially by a competitor, then you can still say this is a trade secrets. Of course, you need to use reasonable measures to maintain secrecy. For example, you use a restrictive measure. For example, you got a passcode, or you have your internal management mechanism, or use confidentiality agreement, all these different ways to maintain the secrecy. And it also got a commercial value. So that's the criteria for the trade secrets protection. There are certain kind of limitation and for the disclosure of trade secrets. The limitation includes if you think of that, usually, the first one is called reverse engineering. The reverse engineering, in fact, is a legal way. You're allowed to do that. If, for example, for your competitor, you go to the public channel to buy a product which is made from using your trade secrets, and then they go back, they do analysis, they unpack it, they reverse engineer it, and then they figure out how to do it, then of course they can disclose the information. That's not a misappropriation of the information. This is legal. The others, in fact, for example, in Australia, we have other situation. You can just not disclose the trade secrets. What's called iniquity rule. The iniquity rule is that you cannot keep others to maintain the secrecy or confidentiality to let them to become a criminal, right? Otherwise, it's unequal to others. The second, of course, the most commonly used is of course, the public interest exception. However, this public interest exception is that you have to, it's subject to a balancing test of a public interest. You should draw first. You should draw a clear line between the interest. Maybe this is the public interest that this should to be disclosed in public interest, or on the other hand, is the interest of the public, or in the public interest, who a lot of people would like to get to know your information. Okay, that's why you have to draw this line. The secondly, I think in Australia cases also shows that for the public interest disclosure, you cannot compare the proprietor to share the information, to compare them, to disclose the information just for something to benefit to the public. Okay, so that's why you see this also got limitations in that. For the public interest exception, you probably also can find for example, Article 5 of the Trade Secrets Directive in EU, right? EU Trade Secrets Directive. And also this is also the test. This kind of a test can also be found in UK law. The third kind of a disclosure is the compared disclosure. That's the government. They can compare you. That's by legal compulsion. So according to the law, or sometimes they go to the court, you're forced to disclose certain information. But this kind of disclosure is very limited, and also usually it's defensive rather than more responsive, right? So it cannot help to deal with our transparency requirements on the public health. So in this case, we have to think about how to govern artificial intelligence. As we had talked about before, it's transparency in artificial intelligence technology is very important in the public health domains, and then they help to build the trust, and then also is key to the accountability. But we know that for artificial intelligence laws or ethics principles, in traditional ethics focus on individual rights such as patient privacy or informed consent application for the AI in the public health. But in public health sector, it frequently involves a collective interest. For example, maybe a pandemic's prediction or vaccine distribution. So this relates to population health. So this means that it entails more balanced legal and ethical rules between the collective benefits and individual rights. So we really have to think about how to develop a better AI governance model. The model should be the one that maximizes the benefits, also minimizing the harm, right? That's why to think about maybe we should have an incentivizing self-regulation. This can be more effective to rather than relying on this litigation or other kind of formal legal processes. So I just would like to draw upon those literature in reflexive law to discuss maybe more to promote that self-regulation. The reflexive law emphasizes the role of law in steering the social system by promoting self-regulation, and also they don't use this kind of a top-down direct regulatory intervention by the states. They mainly just use based on this to use themselves to use the self-regulation internal reflection. And also the reflexive law envisage the limited role played by the centralized legislation due to social complexity, and places more emphasis on vesting decision-making authority to those that are more familiar with the distinct and the traits of their activities. And also, the law suggests that laws should create a framework that enable social systems to regulate themselves through their own norms and processes, and also emphasizes self-regulation, flexibility, participation, and indirect regulation. The law has also encouraged industries or sectors to develop their own rules and standards, and the stakeholders will be involved in the creation and enforcement of law norms, while the state provides guidelines and frameworks, but does not impose detailed rules. At the same time, it will allow for adaptation and the evolution of rules in response to changing circumstances. Basically, it requires that maybe the state at the state level is more formal level. Then you just issue some frameworks and let the society develop more self-regulatory rules. And then in that way, it can be more adaptable, can be flexible to help that can help develop this governance of artificial intelligence. And of course, here I would like to have a look at some of this, to leave some decision-making authorities to develop this kind of rules, right? So we can look at, for example, WHO, World Health Organization, or UNESCO, or international. Sorry, I should go back. International Bioethics Committee on Big Data and Health, and also, like say, the industries like the IEEE, Institute of Electrical and Electronics Engineers. So here I would like to go through some of these kind of we call it soft law rules or self-regulation rules, instead of going through relying on some formal legal rules. I know that like EU, they have an AI Act. I'm not going to look at that. I just look at these rules. For example, in the World Health Organization, it also issued that as an ethics and the governance of artificial intelligence for health. They also offer guidance. They also got the key ethical principles for use of artificial intelligence for health, including transparency, explainability, and intelligibility. And in this rule, in this principle, it says that transparency means that you got sufficient information be published or documented before the design and the deployment of an AI technology. The information should be able to facilitate meaningful public consultation and a debate on how AI is designed and used. And the information should be published, documented in a regular and a timely manner ever after approval for use. Transparency should include accurate information about the assumptions and the limitations of the technology, operating protocols, the properties of the data, including methods of data collection, processing, and labeling, and development of the algorithmic model in order that AI technology can be audited in case of something goes wrong. You see here, they offer more, I think even at this level, it's very general. Of course, that's why we need more like a detailed and more which sort of information can be shared. So possibly we also can have to rely on more like an industry sector to develop a more self-regulatory, maybe code of conduct or guidance. Here I only find like now you got the Institute of Electrical Electronic Engineers got these standards for transparency, for autonomous systems, but specifically in our health context, especially public health context, maybe we needed to, in future, hope that in future we can see more self-regulatory regulational codes, conducts, or guidance. This is another one from UNESCO, got a guidance and the principle for the use for AI in general and for the use of big data in health. Like they got a recommendation on the ethics of artificial intelligence. And of course, I'm not going to go through this. They just say that they cover 11 policy areas. One of these, of course, they say that one is that here member states should set clear requirement for AI system transparency and explainability so as to help ensure the trustworthy of the full AI system life cycle. So that's from UNESCO. And domestically, you also have some kind of initiatives or some kind of guidelines. For example, in UK, you got the UK NHS, National Health Services. They issued also guidance like a code of conduct for data-driven health and care technology. And also the guide also provides with the transparency in limitation on using health data, but that one also for privacy protection of this. But Australia so far has no specific code of conduct in governing AI in health context. So in 2024 September, the Government of Health and Aged Care issued a kind of safe and responsible artificial intelligence in healthcare legislation and regulation review for public consultation. And in this paper, transparency issue has also been raised about how to manage transparency for AI use, either AI is involved in healthcare or patients' data are used for AI products. And Australia only got their own AI ethics principles in 2019. And also the principle of transparency and explainability means that there should be transparency and responsible disclosure so people can understand when they are being significantly impacted by AI and can find out when an AI system is engaging with them. So this all depends on the voluntary, we can enforcement. But in this way, I think that it's very flexible. They can, if you are the authority making decision, you can just issue some kind of guidelines, principles in the area But now in this how much information should be shared, how we can share the information, maybe we also have to rely on more like industries or the private sectors to maybe develop more self-regulation codes or maybe other kind of guidelines. But here you also can see that the development of the concept of a transparency of artificial intelligence. Generally now they said that it has gone two stages. In the past, there's interchangeable concepts like say what is transparency, but it's equal to like say explainability, interpretability, or traceability or intelligibility, right? But now you can see that you needed such information, and then they will provide more like a specific list of the information to be shared. That's why I think that in this case it's good to have this self-regulation and slowly, because keep on changing, so slowly they can then clarify what sort of information should be shared and how can be shared. So this come to my some concluding thoughts. I think that for the AI, artificial intelligence, this development of this kind of technology is really challenging every aspects of life, and also transparency of artificial intelligence is also very crucial in public health context. We need to have a certain kind of transparency. But trade secrets law means that the transparency can be very limited because you have to maintain the secrecy. But only in exceptional situations, trade secrets can be disclosed. So my suggestion is that given the complexities of health and the trade secrets law and ever developing of AI technology, the governance of AI should offer more flexibilities. And also that's why I think that more self-regulation rules should be encouraged to meet the challenges in the ever-changing and far-penetrating technology of artificial intelligence. So this is my talk. Thank you very much, and thank you for attention. Any questions? Yes.
So we have received a number of very interesting questions from the audience. So first, we have one question from Zoe Shuki Woon. So she asked about the AI self-regulation. So basically, she is interested in knowing at this moment how this self-regulation has been enforced. Do you have any examples or any data to illustrate under what scenario some of the, for example, health service providers they might subject themselves to this self-regulation. The examples that you provided, such as the IEEE best practice or those published by the Australian government, because we all know all these best practice or guiding principles are out there. But I think the audience is really interested in knowing to what extent they can have some impact on the industry, or they are just so guiding principles, but without much effect.
Yeah, first, I have to say that, at this moment, I don't have a specific data about how to enforce. First, there are several reasons. First is that, I think in this area for the governance of artificial intelligence is still evolving, is still changing. For example, the understanding of the concept of transparency of AI is an evolving concept, and then they're still trying to clarify what does it mean by transparency. What I would like to suggest that because of this kind of we call them the self-regulation codes or print guidelines. In this way, we help. If you got more and more of this kind of self-regulation codes or code of conducts or guidelines, it can help us to clarify the concept. And then, this kind of soft law, at a certain stage, they can become hard law. There's a process from soft law to hard law. So that's why you think that, of course, soft law cannot be enforced by using the formal legal mechanism. It depends on the voluntary enforcement. But I think at this moment is the best way to use this because the concept is developing, is evolving, and then we call this so-called legalization process from soft law getting to become hard law. So with this, slowly you can clarify this, and also slowly to become hard law. Maybe in future we can let it become hard law. So we rely on the actual enforcement, whether they will have issues or not. And also we rely on more of this kind of self-regulation codes or guidelines to be issued, especially by the industries, the private sectors. And then in that way, we can help to, to clarify this ever-changing technology, the concepts involved in this ever-changing technology, and hope that in the future it can really get enforced through the more formal legal process.
Right. Thank you, Ping. The second question is about existing hard law. So this is also from the audience. So let me read this question. Dr. Xiong, thank you for your sharing. To what extent that you can see existing trade secret limitation might provide a solution to this transparency AI issue in the health industry?
Thank you. That's a very interesting question. In fact, it's also a good question. In fact, in the law for the AI law, for example, you got the EU AI Act. Article 10 also deals with deals a little bit about the transparency issue. And then in that law, they said that, they listed like sort of specific elements or the information should be shared. But for these kind of limitation on the trade secrets law, I think that's a good argument, especially during the COVID period time. We find that lots of people they cannot get access to lots of medical equipments, their medicines, all this issue. Then they start to think about the issue, and also I start to look at some research or literature. They start to discuss. Some viewed this from political economy issue, or because they think that there's a huge private pharmaceutical industries interest got involved. That's why they would like to use this trade secrets to protect their own interest, because trade secrets can protect those kind of protein ideas when they try to develop pharmaceuticals, or some can be used to protect those unpatentable information, right? If it cannot be patented, or I know some pharmaceutical companies, they just use patent to protect the pharmaceutical patented drugs, but they also use trade secrets to protect other bits like the know-how, even show how, all those, they combine them together. Then even though in the future, those trade secrets or the patent got, is in the public domain, then they still can use trade secrets to protect their developed, a brand name like pharmaceuticals. So they talk about this, this literally say that, this, you can see this, between the public, they would like to get access to this information, especially during the COVID time. They think that, then they're talking about maybe, we have to talk about this compelled disclosure. So compel this to disclose. But so far as the law deals with this, we cannot just say that you compare them just for your benefit, okay? You have to have a case. This is case by case analysis, public interest case. You have to analyze this interest is in the public, is the public interest outweighs like, the general public. They're very curious, they're interested in you knowing the information.
Thank you, Ping. The next question is more technical but fundamental. Someone asked that Dr. Xiong, you started your presentation by introducing the notion of AI transparency. But in some of the self-regulation statements, they use similar but different terms, such as AI explainability or interpretability. Can you explain, are they the same concept or they are somehow different?
Thank you. That's a really good question, because as I mentioned in the almost the last slides, I think that this concept of a transparency is also evolving, it's changing. They at least so far got the two stages. At the first stage, it looks like they got this like a transparency in explainability, interpretability, or traceability, or intelligibility. They think this is interchangeable concepts. And that's the first stage. But so far, I think now they're talking about it, if you look at those synchronizations, they start to say this is different to the concepts now. Explainability and also transparency can be different. And that's why I think that we need more of this kind of self-regulation rules. You can see this is developing slowly, and that's why we need more clarification in the future through the industries, through the decision-making bodies, to issue more self-regulation rules or guidelines to help us to elucidate this kind of concept.
All right. So the next two questions are actually from two different people, but I think it would be good to raise them together because both questions are about different types of self-regulation. First question is that Dr. Xiong, after studying all this self-regulation published by different entities, do you see any differences in their content? So that is the first question. And the second question is that Dr. Xiong, would it be possible for you to evaluate or even predict the effectiveness of the self-regulation issued by different agencies? Can we say that, for example, those coming from industry are more effective, or those coming from the government would be more effective?
Thank you. First, let me just answer the last question first. This is still about the effectiveness, because self-regulation, they cannot rely on the formal legal system to get it enforced. That's why it's mainly rely on your voluntary enforcement. And of course, this kind of voluntary enforcement does not mean that it has no effect. In fact, they can also have, unless you have very strong argument or strong reason, usually you don't violate, right? Usually like the decision-making bodies or the industries, they make this the issue, the guidelines. Of course, you have to, better to follow, and then they'll have a certain kind of ways to to enforce it. Of course, here in the health sector, I cannot say that, I cannot say which one is better from the industry sector or from the government authorities, which one is more effective. But I cannot make a comparison. For example, in corporate law, company law, we also have like a corporate social responsibility, right? Also, sometimes it's also in the form of self-regulation or for guidelines. But how can it be enforced? For example, they also got ways. If you're a public listed company, if you don't, meet those standards, you can be delisted, right? That's the way they help them to reinforce. So it depends, the enforcement, the organizations, whether they how they will influence it, or whether they have this kind of capacity, power to influence to enforce it. Okay, that's the first one. And the first one, I think they want me to evaluate, right? What's the trend of the transparency? Is that the question? The first question, yeah. I haven't evaluated, compared all this yet. I haven't compared this, but I think that as I said before, this one, because it's so new, I think that everybody is talking about having the transparency, like WHO. Just now if we look at that information, they said that you should document it, you should develop all this information. That's what they discussed at this moment. This is what they want, and then I don't know how much information should be shared. And also, I'm curious that I also would like to know from the response from the industries, because they are probably the developers or deployers. They would know that what sort of information they would like to share, what sort of information they don't want to share. But from the health, maybe the organ regulators or their perspective, they probably will know that also information must be shared. And also, some share can be limited to share. For example, you only share to certain authorities. For example, you have to look at the rationale behind it. If it's for safety issue or for like effectiveness issue, whether it's just a limited disclosure to certain government authority in order to receive approval. But for other issue, you want people to know more, the general public, right? They hope that they can have more trust in your system or get informed with your decision making. Whether that information should be shared to the general public or not, then I think that these different organizations, the industries, they will be expert in their, of course I can say, in their subject matter. Okay, that's why they will know what sort of information to be shared, and then they will develop this kind of self-regulation codes, and then hope in future we can develop into a kind of hard law.
All right, thank you, Ping. The next question is about theory. So Dr. Xiong, so thank you for introducing the reflective law theory.
Yeah.
I am wondering, how do you see the role played by the market? So is that possible that eventually all these consumers would prefer health service providers that are more transparent? Or probably most of the patient or individual consumers, they don't know that much about AI transparency, so they would still prefer the service or products which might be cheaper.
Yeah, that's why this relates to the rationale of transparency between the different stakeholders. So in the market, of course, you can have consumers. What sort of information they want? Is that they want? I think consumers will care about a safety issue, right? Quality issue is like that. Or maybe it's for some, if you have to pay, you're the payer. Maybe you care about whether this is cost effective or not for the price you pay, right? That's why we needed to really research to decide what sort of information is really for the sake of safety and quality. That's for the marketing. You should know, right? What sort of information maybe is really the business information, then they can maintain to themselves. Then I think that that's still come to to my point that I think that leave to the market, leave to all the different stakeholders to issue their rules to decide, and then finally we can clarify the concept.
Mhm. All right, the next one, this is from U-Tree Springleaf. So who asked about something really fundamental, which might go beyond trade secret law. The question is about how do you see the impact of AI on the whole legal system? To what extent that you can see AI will rewrite the law. For example, the standard of a reasonable person in tort law, how the court would apply existing doctrines. And other than that, do you think existing legal doctrines or existing laws would be sufficiently address the challenges by AI?
That's really a big question now. We also, it has been discussed, and also lots of people are discussing, right? As I said, that AI is really transforming the societies and industries, including our legal industries, right? Like lawyers maybe can in the future, do we have the legal profession like to be lawyers? Lots of paperwork can be done by AI, and also you talk about like in tort law and the reasonable person stand, all these, whether, and also, in future, even judges, if they make a decision, whether they can also use AI to make a decision or not, but because, they can have lots, rely on big data and then do this. And also, I think another issue we have to care about is that the discrimination issue, because, when you have to make a decision, you have to make sure that, the how can we avoid discrimination? I think that currently you can rely on technology. Technology. I once consulted some kind of a technical expert, like they have their ways to when they do the data training, the data mining or data training, they say data mining. When they do that, they have ways there's a masking data or red line data. Use these ways to try to train the data to make sure that they can avoid the discrimination. But others did the research to say that in fact when you use the way to do the research to train your data, maybe from the root still you can have a discrimination. So in that regard, I would say that so in the legal area, you need to ensure there's equity and justice, and we have to be very careful with this kind of automated decision-making devices.
All right. So I think we are about to end the session, but before that, I think Dr. Xiong can answer one more question. So I just received a question. So the audience sent a question to Cherry. So the question is more about international competition. Is he or she asked that Dr. Xiong, so how do you see all these differences in international competition, especially in the health sector? So for example, if there is one country who focus more on responsible AI, so which might, of course, impose more transparency requirement, as opposed to another country that purely focus on AI innovation. So would that be an impact on international competition? So among these countries with different requirements and approaches to AI transparency in the health sector, and also to what extent they can be aligned to existing trade secret protection or limitation?
Yeah, that's really interesting. No, very, of course, good question. I think that for the international competition, of course, not every developers deploys, they have their preferences. Some just focus on innovation, and then possibly they rely on this trade secrets protection more because they have to invest and then to protect the investment, right? That's why they need the trade secrets protection, especially at the initial stage when their ideas are pretend and then maybe it's not patentable. They probably rely on more trade secrets protection, but the others, they all rely on the responsive, AI, and then they don't mind more transparency. So in that way, I think that that's why we needed to find out the basics. That's why, and also for every industry specific, they have to develop their own code of conduct, see what sort of information can be shared or ought to be shared. Because, in public health sector, maybe, you can see this is for public health, and then you need to share this information, then they will know what sort of information can be shared and should be shared. That's why we can know. Otherwise, you want me to decide, I cannot decide because I'm not the expert in the area. If you do innovation, then you know that, you're probably very strong in maintaining the secrecy, right? Yeah.
Yeah, thank you, Ping, for
Thank
your
you.
sharing. So we are about to end the session. So I believe everyone here, including myself, enjoy a lot, and we learned so much from your insights. So it's wonderful to have you with us, and hope we can have you next time.